in Australia elect our parliaments, and in particular how we get a Prime Minister or head of government. So as you may know, since the fall of Kevin Rudd, Mark I, 10 years ago, we don't elect our Prime Ministers or Premiers in Australia. We don't elect them directly, we don't really elect them indirectly. What we do is we elect parliaments. We elect parliaments largely on party lines, and the majority party in parliament gets to choose its leader. The leader is then installed as the head of government. All of this you probably know, responsible government via representative parliament under party democracy and all of that. If you think about it, the closest we have to an elected president is directly elected mayors. Now, it might seem weird to compare the mayor of Brisbane to the US president. But think about this. We saw a week ago in the Brisbane city elections that we elect a mayor directly. A bit like how the US elects a president. But we elect the mayor on the same day as we elect all the councillors. And that reduces the possibility of what the French call cohabitation. Now, cohabitation sounds sexy, but it's just a label for when the elected head of government might end up being from a different party to the party that dominates the legislature. Now, the Americans, the Yanks, they elect a new House of Representatives every 2 years. They elect senators for 6 years in in rolling cycles. So there's a strong possibility in the United States you get a president who has to cohabit with a House of Representatives or a Senate that comes from a different party to the president. And on top of that, in the United States, the party machines are much more loose, much less powerful than ours, because in Australia, basically all the donations go to the party bosses, the party machines, and the party leaders and activists get to choose their candidates. Whereas in the United States, things are very individualistic. Money flows to individual candidates who try and sell themselves through their charisma. And they have these things called primary elections where ordinary people can go and vote in to say who's going to be the candidate for the Republicans or the Democrats. It's not controlled really by the party activists. All of that that I've just given you is just a background to the idea of impeachment. So what is impeachment? Put simply, it's a way of answering this question. How, if at all, might you get rid of a corrupt or wildly incompetent president who's otherwise guaranteed 4 years? Now in Australia, as I said, we've had 4 prime ministers toppled in the middle of their 3-year term in the last 10 years. None of them, as far as we know, were corrupt. A couple were mildly incompetent, maybe. So obviously there's something very different in our system. Our system is very flexible. But when you have a president with a national electoral mandate, like in the US, things are different. Should the president be locked in for 4 years? Death us do part. Well, the framers of the US Constitution said no. To avoid such locking in, they set up the process whereby the People's House, the House of Representatives, can lay articles of impeachment. And if those articles of impeachment are voted up by the House, those allegations become a formal charge which is sent to the House, to the Senate. And the Senate then tries the allegations, the articles of impeachment. So it's a bit like a magistrate here or a grand jury in the US that commits someone for trial. So the House impeaches, but the Senate has to convict to remove someone. And often the terminology is used loosely. I mean, Trump was impeached, but he obviously wasn't removed from office because the Senate didn't convict him. And the Senate in the US has never actually convicted a president, but it has held 3 trials. Andrew Johnson in the 19th century, Bill, I did not have relations with that woman Clinton in the late 20th century, and then Donald Trump this year. Also, there was one president, Richard Nixon, you may know, he resigned in 1974 when it was clear the House was going to impeach him and the Senate was going to convict him. The test for impeachment is whether there was treason or high crimes and misdemeanors. I won't go into the test, other than to say it was long ago understood that it was not a strict criminal law test. It is a wide term covering gross abuses of power and not just actual criminality. Also, it was always envisaged that impeachment, although a solemn process and a rare process, would be a political process. Not necessarily meant to be party political, but that there would be different factions and ideas in Congress about what was intolerable or corrupting actions and maladministration. All that said, the three attempted impeachments in the last century, that is Clinton, Nixon, and Trump, all saw careful attempts by the House of Representatives to frame charges around fairly legalistic concepts like obstruction of justice or abuse of powers analogous to things like bribery and intimidation. All right, now, a question for you guys. Did the US invent the concept of impeachment to deal solely with its presidency? Well, the answer is no and no. They borrowed it from the British, the regime they were running away from. And also their constitution applies it to all civil officers of the federal government, the United States. So I've mentioned the system is quite different from Australia, and we'll come back to that in a moment. We've had 4 prime ministers removed in the last 10 years under our Westminster system. The US has had 3 presidents tried in the Senate in well over 100 years. They borrowed it from the British. Impeachment has been a thing at Westminster since 1386. That's 400 years before the US even began to be a thing. So that also meant that the US had a lot of experience of local impeachments, especially of judges under the British model through colonial legislatures, even before the US Constitution extended the idea to people like presidents. Well, why did the British hatch this curious idea? Well, in the 14th century, at Westminster, the Parliament wasn't really elected either. But it was seen to be, quote, the High Court of Parliament. Yes, Westminster Parliament's always had some court-like powers, and if you've done law of politics with me, you'll know that. And impeachment was just one important such court-like power. Parliament, the key body outside the monarchy and all the monarchies hanging honours and courtiers, the Parliament had a role in adjudicating guilt. Outrageous, you might say. But if you think about it, back then, the king was otherwise all-powerful. So it was useful to have a partly independent source of power, particularly if, say, the king's advisors and the king's favourites were protected from prosecution. So the UK Parliament could act and remove them from office. So not act to jail them in the criminal sense, but to remove them from office, and impeachment disqualifies someone from future office. The consequence of impeachment is ostracism from public office, not criminal penalties. Now, Trump, like President Nixon, asserted recently that a US president is immune from ordinary prosecution. That claim has never been properly tested in US courts, but you can certainly see the political risks both ways if US prosecutors have to consider filing criminal charges against a president. So impeachment offers an alternative form of justice and accountability, but it's obviously a more public and political process than a mere criminal trial. Now, I said that impeachment began in the UK in the 14th century, and you can see the first Earl of Sussex on your left, who was impeached. But the last time an actual impeachment charge went from the House of Commons to the UK House of Lords was 1806. And you see a picture there of a Scottish Tory who was acquitted of misappropriating public funds. So the House of Lords impeached him, acquitted him, even though the Commons had impeached him. But in the end, he was also seen as having been at least a minimum negligent, and he lost his executive office and he never served in office again. So you can even have an impeachment process that tarnishes someone even if they're not convicted. Now, these days in the UK, impeachment is considered quote unquote obsolete. So there hasn't been anything going on in the impeachment area in the UK for over 200 years. Yet the law sometimes works like a meme. Legal forms and legal actions can spread far from their cradle and they can find homes elsewhere. As I said, in the US, we've had attempts to impeach presidents 3 times in my lifetime. Beyond the US and the UK, impeachment is a thing in some other countries, especially those with presidencies. So South Korea, their first female president was of the name of President Park. She was impeached and removed for corruption by the legislature only 3 years ago. She also went on to be convicted and sentenced to 24 years jail. So it really was a double whammy for her. Okay, moving on from impeachment as a process and idea, how does it fit with the separation of powers? Now, often today we have a very simplistic idea of a rigid or strong separation of powers. You got to keep the legislature and the executive and the judicial arms distinct. But this was not always the case. And if you think about it, if the aim is to limit the power of any one branch, if that is one of the aims of separation of powers, then far from cutting across the separation of powers, impeachment of one branch, say the president, the chief executive, by another branch, Congress, can offer a check and balance. And as I said, that was really the original UK purpose of it. To have a limit on the otherwise self-policing monarchy and executive, and a limit that was in some ways democratic and certainly open and political. So in theory, a British Prime Minister or Minister could be impeached by Parliament. But under the Westminster system as we now have it, there's no need to. The British Prime Minister, like ours, can be charged under ordinary criminal law and might lose office and be disqualified if they're convicted under ordinary criminal law. But in any event, politically, a British Prime Minister like ours owes her tenure to having majority support in the lower house, and their ministers are also responsible to Parliament, where they all have to sit. So there's already a political process to get rid of a Prime Minister in a fused Westminster system. But in the US, the system of separation of executive from legislature is much stronger than over here. Trump is not a member of Congress. Indeed, the one thing Trump's cabinet can't be is to be members of Congress. And you might say, well, why can't Trump then impeach members of Congress if members of Congress can impeach him? He doesn't have that power. It would be overweening if he did have that power, but certainly members of Congress can be charged by the Justice Department or the FBI, and they can be legitimately prosecuted for ordinary criminal charges. Now, I mentioned this old idea that Westminster parliaments, including the Australian Parliament, derived from the Westminster model, are sometimes called the High Court of Parliament. And to some people, that idea of a parliament also being a court, in some ways, it offends the sacredness of judicial power. So we balk at this term today. Parliament is not a court. But there are remnants of the fact that Parliament was once known as the High Court of Parliament, besides the impeachment idea. So modern legislatures, even in Australia, have some judicial style power. And again, you'll know this if you study the law of politics with me. So here's two more examples. One is their ability to rule on contempt of Parliament. Indeed, old-fashioned parliaments used to have a little lockup or jail cell under them for people who might have been sentenced to contempt. And the picture there that's now a wine cellar, that's from the Queensland Parliament, and that I think used to be allegedly the cell in which people who committed offences within the grounds of Parliament, including special offences like contempt against Parliament, could be locked up pending further dealings with. The last time this happened in Australia at the national level was back in the 1950s, and you'll see the story there where the Australian Commonwealth Parliament actually sentenced two journalists to jail for contempt of Parliament. They didn't serve their time in a little lockup underneath the Commonwealth Parliament, they served it in an ordinary jail. That was such an extreme case that it's never happened again. But Parliament still has power to sanction people with fines and reprimands and so on for contempt of Parliament. The other kind of quasi-judicial power that all our parliaments still have, which you will have heard about in the last few years, is they can make judgments about whether an MP is qualified or disqualified. And we've seen that in recent years. For instance, the Commonwealth Parliament decided not to refer Peter Dutton to the High Court of Australia. So whilst the Parliament can refer matters to the courts, ultimately under Section 47 of our Constitution, the original power lies with Parliament, and Parliament can exercise it completely if it chose to. Now, right, you might say these are historical anomalies, Graeme, contempt of Parliament, MP disqualifications, impeachment, they all sound pretty musty. You might say, give us a Chapter 3 wall from the Constitution give us a clean division of judicial power from non-judicial powers. And it's certainly true. In Australia, we have no impeachment clause in our Constitution, and so it's really unarguable. We don't have any power to impeach public officers from the Prime Minister through to members of the Commonwealth Public Service using impeachment the way that the US Congress can impeach and has impeached secretaries, presidents, and other federal officials in the US. But buried in Chapter 3 of our Constitution, and here's a bit of black letter law for you on a Thursday afternoon. You may remember going right back to public law. Buried in Chapter 3, Section 72 is the power for effectively the Australian Parliament to remove Commonwealth judges. If you look at the process, it sounds a lot like impeachment. A Commonwealth judge shall only be removed on an address, which is like a petition, agreed to by both houses of the Commonwealth Parliament. And if that happens, the Governor-General would have to remove a Commonwealth judge. And we have very similar provisions in all the state constitutions. Now, you might think, Parliament adjudicating about proven misbehaviour or incapacity to remove a judge, it feels like a kind of sanction, removal from office, for past conduct, bad behaviour, or incapacity, existing inability to be a judge. And it all feels like judicial power. Finding facts, applying legal tests, a binding order. What's Parliament doing exercising this kind of judicial power? Why aren't the courts given this kind of power to remove judges? When you think about it, a strong separation of judicial power is not just about safeguarding judicial power for judges from other branches. It's also about judicial independence. And judicial independence is not just about independence from the other branches, it's also about judges being independent from each other. And if you had to give a bench of judges the power to sack a fellow judge or a lower court judge, that would be very awkward indeed for their separation and independence from each other. Now, some of you may know this, others, this might be news to you. Queensland is the one jurisdiction where a parliament in this country has impeached a Superior Court judge since Federation in 1900. And that judge is the older guy there on the left of your screen. And it was 31 years ago. His name was Justice Angelo Vasta, QC. He was impeached or removed under the address and prayer process by the Queensland Parliament to the Governor. He was removed for two things, neither of which related to misconduct on the bench. They were related to previous things that had happened before he became a judge when he was a QC. One was that he was found to have lied in a court case in his earlier private life in a defamation case that he had brought. And the other was that he had alleged to have misconduct in his tax affairs. Now, you might have heard the name Vasta, not necessarily because of Justice Vasta, but also because it's quite a family. The young guy there who's with him in the black and white photo is now a senior Liberal politician in Canberra, but based in Brisbane, called Ross Vasta. And then the guy in the colour photograph at the bottom has been much in the news lately. He is a federal circuit judge, Salvatore Vasta, who has been in the news under fire because, for example, he's locked up litigants for contempt, and some of his very egregious judgments have been swatted down on appeal. But there's no suggestion today that the younger Justice Vasta should be removed from office. He's receiving more modern help, like adjusted workload and other counselling, I believe. So there are other ways to deal with judges and their performance and capacity without going to the nuclear option. Now, you might say this, Queensland Parliament has only one house, usually controlled by the government of the day, Labor at the moment. Can we really trust a single House of Parliament to remove judges? Well, Maybe not. But in Queensland's case, in the Vasta case, it established a rule to act after a report from an independent commission. So in other words, Parliament said, we want to hear from an independent commission of inquiry headed by a retired former judge who will look into the Vasta matter. And then if they recommend we consider impeachment, we will consider impeachment. So if you like, they set up an extra chamber, a bit like the way the US Congress or the Australian Parliament has the two chambers to deal with impeachments. So all up, as a way of removing judges, this kind of idea of impeachment has hardly been overused. But back to the United States. Imagine in the US giving a bench of judges, current or retired, the power to impeach a politician. Yeah, so if you really strictly believe in the separation of powers and due process, you might say, I don't like the idea of Congress, which is a highly political body, removing a president. But who else is going to do it? If you gave it to judges, well, they're above politics in some way, but it would imperil the appearance of judicial independence. Even the mere fact that the US Constitution had the US Chief Justice presiding, like a judge over the jury, over the trial of President Trump in the Senate, raised a lot of eyebrows around the world. As a result, when the Chief Justice presides over a trial in the Senate, an impeachment trial, they really don't act like a judge over a trial. They act more like a chair of a self-governing meeting. They avoid making any contentious rulings. They put any contentious rulings on stuff like, what evidence are we going to hear, guys? They put that to the Senate. And then it becomes a semi-political matter. So in Trump's case, the US Senate were much more than jurors finding the facts, sifting through for legal relevance. They actively shaped their own hearings and which facts they get to be exposed to. And enough Republicans who were in the majority declined to hear new witnesses, and that left Democrats feeling that the process was half-baked. It wasn't a real trial because not all the evidence got heard. All right, none of this is to say that you couldn't have a system with an independent body of retired judges who could be trusted to rise above speculation about them being partisan and to try an impeachment fairly. And indeed, I said earlier that in the Commonwealth Parliament has said in most cases of dealing with qualifications of MPs, they'll outsource that matter to the High Court. But a question like, is an MP a dual citizen? That's a fairly narrow and much more legalistic question than a much messier question such as, has a judge been engaged in proven misbehaviour such that they should be removed from office? Or has a president been engaged in high crimes or misdemeanours? That's a much messier, broader kind of public policy question. And we might want to keep judges clean of such issues. So to sum up and wrap up, ultimately the question of impeachment boils down to questions that are actually not as lofty as the separation of powers. They're actually questions about due process, partiality, about which institution in terms of propriety and practicality is the best branch to handle these very rare but necessary allegations about removing major public officials. And I'll end on a practical note. To say that a legislature should have impeachment power is not to say it can only be exercised in a partisan way. Legislatures are pretty good at setting up committees with a balance of members of different parties on them to investigate whether to recommend something like impeachment and on what basis. These committees hold public hearings, so they're accountable. They have legal counsel, so they're well advised. They glean much more wider evidence than judicial hearings could ever do with rules against hearsay and so on. So they're more inquisitive. And those hearings can be tailored to give due process. Now, as I said, the US process, I think, miscarried in Trump's case because things were too heated. Trump's team withheld evidence. They were running down the clock, refusing to answer subpoenas from the House of Representatives, and then the Senate didn't care to have a full-on trial. But back in Bill Clinton's case about sexual misconduct and lying to a grand jury, Clinton was rightly chastised, but the Senate also realised that the charges of covering sexual misconduct didn't really fit the test of high crimes or misdemeanours. And in a way, it acted the way a community jury would, applying common sense. Okay, so that ends my lesson for today.